whispers and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on Earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause. Welcome to The Probable Cause. This is a podcast covering the legal system in Allen County, Indiana, northeastern Indiana, and the state of Indiana. I'm your host, Jamie Duffy, a local journalist, and to my left is Michael McAlexander, our co-host and the Allen County prosecutor. Now, normally we would have with us my right hand on the cell phone. She can't be with us today, and thoughts and prayers are welcome for a speedy recovery. It is just a small setback, but she has been through a time of it. Now, last week we also heard from our producer, Eastom, who had a pertinent question about jurors. So it's kind of turning into a party here. We had an interesting time last week with the Allen County Chief Public Defender, William Libredo. So we'd like to encourage you to watch that episode by going to our website, www.theprobablecause.com, or our Facebook page, The Probable Cause. This week, we are going to talk about how prosecutors determine the appropriate charge, something that Mike is all too familiar with. It's something I often wonder about when I think about cases and when I read cases. But first, I want to issue a personal apology. When you're wrong, and a correction is immediately due. Yesterday, someone pointed out a mistake that I made in the story, which is another follow-up on the Pikes Pub 6. These are the 6 defendants who are accused of beating a black man in the May 30th beating at Pikes Pub in Waynedale. I made a mistake to say that the criminal gang enhancement had been replaced by a felony 6 criminal organization activity. Now, that is absolutely untrue. My apologies in particular to Tom Shaley, our chief deputy prosecutor, who is kind of trailblazing these charges. I understand we haven't applied these charges for maybe decades in Allen County, and that was brought out last week during our podcast with Mr. Libredo. And I don't know if you will find a completely revamped article with a correction online on the Probable Cause Facebook page and my own personal page. I don't know, Mike, if you wanted to add a few comments on that situation.
A couple.
Okay.
This is exactly the reason why so many public officials distrust the news media. In this particular situation, this is a pending case. I don't talk about pending cases.
Exactly.
But when you're reporting about something that happened and in court and you weren't there, I think the media has a duty to investigate. I have a fair number of people in my office that think I'm nuts for doing this co-hosting with you.
Not true, not true.
And to give you the kind of, inside access. And what I've told them, and I don't know if I've ever said this during any of our podcasts, the reason I do it is because there is so much misinformation out there about the criminal justice system, about what we do, so many assumptions. So for me, I do this hopefully to educate, hopefully to explain some of what goes on that you're not going to get in a newspaper article about a sentencing in a murder case,
right,
which is what most of us are seeing these days from the local media. I also understand that the legal system can be very confusing. It can be difficult for the public to understand. It's difficult for individuals to understand. If you don't know the precise meaning of some of the words, it can have a completely different impact. So I tolerate a lot of what would otherwise be bad journalism. I mean, I've been involved in one form or another, probably in thousands of cases over the years. And almost always I can find something that is wrong in a news account about a trial or a sentencing or what happened in court. So, there's a little bit of tolerance. But in this particular instance, I certainly feel like you took what you thought you had a big scoop and ran with it without doing the kind of things that I've seen you do before, which is verify your story. Now, you have told me that you read the chronological case summary, you saw something, and you went with it. It's disappointing to me because I know you have all of my contact information. I know you have Chief Deputy Tom Shaley's contact information because he frequently helps you and lets you know when we get verdicts on cases that you're not able to physically be there.
Right.
This office tries to respond to the media all the time. We produce probable cause affidavits for them. We bend over backwards. So and we've generally always tried to respond to the media when asked. Now, sometimes that response is going to be, we can't comment on that because there are rules of professional responsibility that limit what we can say. But we still try to get back and at least let people know that we're aware of the case. It's under investigation. And I understand as a journalist, you may not like that answer. It's boring. It doesn't tell you anything, but we try our best to get back to people. So to have a case that obviously is getting a lot of public attention and to report on dismissal of charges, and then to get comment from a local, I don't know what she portrays herself as an influencer or activist.
Activist, she would be.
But to get comments that are negative about the office, about the system, about what we did, and one, not give us a chance to respond or explain or even to verify that what you're reporting was accurate, I think was irresponsible. And I appreciate your apology, but this is the reason why at the national level you hear fake news or biased reporting, and we can all argue whether CNN and Fox News and News Nation and Newsmax and MSNBC and the Washington Post and Time Magazine and all of that
New York Times
are biased. Yeah, just go through the list. But that is why public officials look at the media with a lot of concern and skepticism because of things like that. There are times, it seems, when the media is more interested in getting it first than getting it right. And for me, when we have given you this kind of access, I'm very disappointed, to say the least, about what happened. But it's not just you. It has happened with TV stations. We bend over backwards with them, and then they report something either inaccurately or say we haven't responded when we either got virtually no notice, or I'm saying, who did they call? Because I can't find one person on my staff that received a call from them. So this stuff happens. I understand mistakes, but some of them are just unprofessional. So.
Right. Well said. And I appreciate your comment. And hopefully we can continue to be friendly. That's what I'm hoping.
I believe in civility.
I know, I do too. So I think one of the things we should talk about this week, which we always do, is the courts. Now, I thought we'd have about 3 murder trials and 1 attempted murder trial this week. We don't have any because they've been bumped, as Mike said. Defense motions, and one was a plea deal for the attempted murder. So what do we have in courts this week that people might check on?
We had 3 trials start yesterday. We just got a verdict on a domestic violence case.
And was that guilty or not guilty?
Guilty.
Okay.
We had a case yesterday that went to trial, and unfortunately, during the course of the case, a witness referenced that the defendant had just gotten out of prison. Well, that's one of those things that we're not supposed to talk about because it potentially influences the jury to believing that, oh, if they were in prison, I don't know what they did that time, but that probably means they did this one as well.
Right.
So we keep those references away, and that's why if you attend a trial, you won't, if we show a picture that's been taken at the jail of the defendant, commonly referred to as a mugshot, or their criminal history as a rap sheet, we won't use those terms because that can trigger a mistrial and bias the jury against
but in the closings, is the defense attorney or the prosecutor allowed to use those terms? Like rap sheet?
No.
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 And what kind of trial was that one where there was a mistrial?
It was a residential entry, I believe, and might have had a possession of a handgun. So we have another case that's somewhat similar in terms of a gun case that is in its second day. It took them almost, I think, till 4 o'clock yesterday to get a jury.
Oh my gosh.
And get a jury means to select the jury. For whatever reason, we've had that the last couple of weeks, spending all day. As you know, normally we start a trial on a Tuesday morning and we'll have the jury by sometime over the lunch hour.
Right.
Sometimes it'll go till 1:30 or 2, but usually we've got the jury then in the last.
Right, and you usually have time to get the openings in.
Yeah. Now sometimes you have difficult cases, child molesting cases. Frequently, there's more strikes for cause because of the nature of the crime. People either have had some experience in themselves that they don't feel they can be fair, and it triggers some kind of PTSD, or it's just the topic they don't want to deal with it. And murder cases can be that way, that some people feel they shouldn't sit in judgment on other people.
Oh, wow.
On that. So, so we do have one going. We also had one set yesterday. A pet peeve of mine right now is pro se defendants.
Oh,
and
dear.
Pro se defendants.
Oh, I should be covering that.
I mean, defendants that choose to represent themselves.
Right.
And yesterday we had a case set that would have gone, but the defendant came in and on the day of his trial acknowledges that he can't function as an attorney on his own.
Oh,
he would be out of his league and couldn't give himself a fair trial.
So is it going on?
No, they continued it.
Right. I want to point out in pro se, if you are a language person like I am, if you've ever taken Spanish or French, you know that the SE refers back to a person. And if you know those languages, then you can figure out what pro se means. Sorry, keep going.
So we really need to do a better job on that. We've had several of those, a couple of them relatively high profile cases that the defendants chose to represent themselves, but as the case progressed, they realized they couldn't do it. Especially if they were sitting in jail, they didn't have access to investigate or interview witnesses beforehand. I think it gets back to, I mean, we talked last week with Bill Obredo on this sense that if they've got a public defender, they don't have a real lawyer.
Which is not true.
And we discussed that extensively last week, that some of the best trial lawyers around are public defenders. But as an office, I'm hopeful that we can get our people, and hopefully the judges, there's some case law in this that allow the judges to do more of an examination as to whether somebody has the education and the background to be able to represent themselves.
Are the judges kind of reluctant to do that sometimes?
Well, it's where a defendant has that right to represent himself.
Right.
How much do you dive into that to protect him from himself? And the case law has been somewhat open, but as a professional with the technology involved, I don't send new lawyers in to do major cases till they've got quite a bit of experience.
And Bill Labredo's the same way.
And so to take somebody who's a high school dropout or just a high school education, who's getting his legal advice from fellow inmates at the jail,
right,
is stupid. I mean, and in good faith, it's not a fair fight. I want to win. I believe in our cases when we file them, but I also want it to be good on appeal. And if we put an ineffective defendant, it gets tricky because he chose it and he's advised that this isn't a good idea. But I really think that maybe we need to stress to the court and stress to the defendant and get in there and explain the kind of evidence that we've got and what they don't know about the law.
But wouldn't you have to do that anyway, even if he had a defense attorney? Don't you have to show the evidence that you have?
We have to show the evidence, but I'm not sure that these guys understand the first thing about picking a jury, or what the reasons to strike somebody are, or what are cause strikes. So they're putting themselves in a position where they don't know kind of the unwritten stuff as they get started.
I feel like that could take forever in a trial.
Oh, it can.
It might take 3 days to just get a jury because of the...
Well, we also have trouble with, if they're in custody, we've had issues with sharing discovery with them.
Oh, yeah.
And they don't even know what to do with half of it. And we give them a disc. They are not necessarily technologically on top of it.
Do they even have a place in the jail to insert the
Some
disc?
stuff they can watch it on their laptop or
their tablets.
But it's really just not going to be a fair fight. And they're usually asking to represent themselves not out of a source of education. It's out of some unrealized belief that the system is stacked against them. Well, if they want it stacked against them, represent yourself. There is an old line among lawyers about a lawyer who represents himself has a fool for a client.
I've heard that.
And part of what you're looking for is the objectivity. We've talked about plea agreements before. Part of that objectivity is knowing how good your case is. Is it a strong case for the state? Is it a strong case for the defense? You might presume that most cases are going to be strong for the state. Well, of course they are. We have the higher burden. We wouldn't file them if we didn't have a reasonable belief, and ethically we have to have that reasonable belief that we will prevail. So those are all things that kind of get into how we're doing things. And I think we need to take a little more aggressive stance to really put them on the hot seat before we start the trial. And because this gets into another thing that with the number of trials we have set, our folks are spending a lot of time getting prepared for cases, and then they don't go. So they're giving up personal time with their families. But probably even more important, I think as a system, we tend to forget the emotional impact on our victims. That last week, for example, we had 2 child molest cases, and one of them ended up with a hung jury.
Again?
And we got the dreaded Well, we believe the victim, but we just needed more. And those are extremely difficult cases with it usually comes down to the victim's word versus the defendant's word.
Are you going to try it again?
We're still reevaluating it, and I think we have a meeting set up with the victim on that case to talk about what does she want, where do we go.
So how many years ago, was it?
I'm not completely sure, but it's been in the system for a little while to be tried twice.
That defendant isn't going to give up now because he's had 2 hung juries. So
those cases are very difficult to see pleas on, anyways. But no, it's just really tough on the victims, and I don't know that I can describe that sufficiently because they were traumatized by the original crime, and then the trauma of going into court and talking in front of a jury and whoever is in the audience.
that's right.
And
I know.
particularly if you don't have the full support of your family.
Oh yeah.
And unfortunately, we've had some cases like that recently. So they're just
Sometimes the mother
really
just
tough.
wants to deny it. But I know a couple of cases where there were heavy-duty child molesting and the guy's already out of prison, and those people are furious. So
It's
tough, but you know what? I was going to bring this up later because it's one of the things I want to do about how you choose the charge, because there are a bunch of charges that you can apply to child molesting. You can go all the way up to level 1, but they start out, I think, at level 3 if you've done such and such, right? And it's, I was going to bring up, I can remember there was a woman named Courtney Jenkins who ran the first JCAP program in Indiana out of Kosciuszko County. And she dealt with a lot of people who've been traumatized, who have turned to liquor, who've turned to drugs. A lot of these people do. They can't live with the memory, and so that's what they do. And she said it was unbelievable. It was like 90 or 95% of the people in jail that her statistics said had been molested. It's just lasts through the rest of their lives. And when you turn 18 or 21 and you're an adult, you don't put that behind you all of a sudden. You know, you're not grown up all of a sudden. We all live with childhood trauma, whether, we had a little tiny bit or something like that.
Well, we're all impacted by our experiences that way. And if you have a traumatic incident, particularly both the physical aspect of it, but so often in child molesting cases, these are violations of trust. It is not the boogeyman jumping out from behind the bush and grabbing a kid.
Right.
Most child molests are done by family members or close friends of the victim's family. We joke you're in greater danger at the Thanksgiving table than you are walking down the street when it comes to child molesting.
Or it occurred to me when I was raising my boys that sleepovers offer
potential for a lot of things, and it's very sad, and how that impacts the individual person varies. But drug use, unwanted pregnancies, alcoholism are all things that people are fighting through in response to that.
I know. I have people contact me because they want their stories told, and then I'll say, okay, set that up, but I'm going to need some documents, that this and that. And I think part of it is just cathartic, if I could use that word, to just talk to somebody about it and know that they're interested. But lots of times it doesn't come to pass, if you know what I mean. It's like too much. And then maybe they'll get back to me later. But I have written a few of those up. And before we get on to what we well, we've already discussed part of it today, is that now back to the Pikes Pub 6. What I did get right was the new court date, which is September 26th, in front of Allen Superior Court Judge Fran Gohl. And I was told by people that I respect in the prosecutor's office that all 6 of the defendants will be there and that there will be no hearing this Monday. So, we will just continue to follow up on that story and other stories as they come. So today we're going to start this conversation on how to make the charge fit. As I said, it's an interesting question. Sometimes it looks like charges are piled on so that prosecutors will at least get a charge or 2 if that was the end of their goal. And there's some feeling out there that that is the case. Do you ever think that's the case?
There's a couple of rules of evidence that impact what you charge. I know when I first started doing this many years ago, we had kind of an unwritten rule that you filed your 3 best charges.
Mm-hmm. Now it's your 6 best, or?
Yeah. Well, part of it is changes in the law that the legislature over time has drafted specific instances of behavior that, like I'll just use a simple OWI. Mm-hmm. You're going 70 miles in a 45 zone. So you're driving recklessly. That's also your probable cause, probably, to stop the vehicle by the officer. Well,
and that didn't used to be?
No, that part is.
I mean, they're setting their...
But that sets you up for an OWI causing endangerment because of the speed you were going at.
Okay.
You may also be put down for a reckless driving. Mm-hmm. Then you're offered a test. Well, if you refuse the test, you may still be charged with the OWI if the other indicators of your breath and fumbling and
the gaze.
Yeah, the walk and turn, all of the other tests like that. But if you take the test and are over 0.08, it's a charge of called per se.
Per se? Mm-hmm. Not pro se, per se.
Per se.
Okay.
That just means that in Indiana and most states now, if you have more than 0.08 alcohol in your blood, then you are going to, or your breath alcohol, that is a separate charge on its own due to the determination that that level makes you impaired to operate a motor vehicle. Mm-hmm. But if you're over 0.15, it can be enhanced. So,
because that means you're almost doubly drunk.
Yes. So
I always look at the back when I'm writing those things up.
So, one incident may create a lot of different crimes. I can use another example of, say you're sitting at home watching TV and somebody kicks your door in and comes in, holds you at gunpoint, asks to have, give me your watch and your jewelry kind of thing, and then smacks you across the face with the gun. Okay, you've got a breaking and entering, which technically Indiana calls it residential entry.
Level 6.
Yep. It's also an element of burglary because you're coming in to commit a felony, that you're going to steal something. The fact that you're doing it personally, instead of if they came in and you're asleep and they go in, find your wallet and take off, then you have a burglary with theft.
Okay.
But when they hit you and take the stuff from you, then they've hit you with robbery. That may be enhanced from anywhere from a level 5 up to a level 1 felony, depending on the severity of the injuries.
Would it be a battery?
And it could also be a battery, aggravated battery,
right,
depending on how severe the smack was. It could be attempted murder.
Oh, really?
Yeah.
Just from that smack, it could be attempted murder?
If you were vulnerable, or say they shot you instead of...
Oh, well, though, okay.
If you're an 80-year-old woman versus
yeah.
like a 20-year-old.
Yeah, the age of the person, I think, would
And then
definitely factor in.
you also get into, I think we've talked about the different levels,
So I
like
think what
battery.
you're telling me is that everything's gotten more specific. This is on the child molest thing here. This is if you molest a child on 14 and under. So this is a level 1. This is a level 2. It goes on and on. So it's very specific as to what your behavior was when you molested that child.
Yeah, I mean, in child molesting, there's generally a major breakdown between fondling and touching and having sexual intercourse, oral sex that are more serious. And then you're also looking at the age of the victim primarily and the age of the offender. So different things can trigger different levels of the offense. So when we get into making the decision, there's some things that are basically lesser included offenses that you don't necessarily need. If you've got a good burglary case, do you need to back it up with a theft? Sometimes you do.
So like that lesser included, does that mean that's like, if we have to, we will dismiss that one?
Well, it's not that if we have to. There's a lot of things that are going to merge. Let's say in one of these, we went to trial and we got guilty verdicts on all counts. Well, because they're all based on the same factual situation, many of those would merge together. You wouldn't get a separate sentence that could be made consecutive for, say, the breaking and entering.
So
or the
that's how it
residential.
works. Because when I look in my case, I'll say dismissed, 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 dismissed. And then there's that one that's going to send him to prison.
Yeah, I mean, it gets very complicated at times and confusing, but that is the basic rule behind it. That's also why when I know people look at it and say we have 4 or 5 counts in a child molesting case that are all surrounding one incident, and we plead them to count 1 and dismiss the other ones. It's because those are going to all merge together anyways.
Well, but when somebody molests a child numerous times over time, right? So you'll have the molest charge like repeated 4 or 5 times.
Right.
Do those normally get merged into?
It depends on the case. Because when they are separate incidents that way, they can be consolidated and served concurrently. Under the right circumstances, they can be served consecutively. Generally, multiple victims gets consecutive sentencing. Not always, and certainly in multiple victim cases, it kind of depends on what happened. I mean, we've had that with, say, a car accident or drunken driving where a car is hit, there are 4 people in the car, and let's say the front seat passenger dies, but the other 3 were subject to criminal recklessness.
Or there could be somebody who might have gotten permanent injury
Right.
and not died. So that, to me, would be a separate charge, definitely.
Generally, and quite likely, a consecutive sentence.
So I suppose we should say what concurrent and consecutive are. Concurrent means that you serve that sentence at the same time as the other one. So in other words, let's say you got 6 years on both charges, but you would serve them together, so you'd only do 6 years. But if they were consecutive, then you'd end up doing 12 years. Did I say that right?
Yep.
Okay. So, and then I noticed on, I was talking to Mike before we started, there is one that's a recent murder, and the man is charged with murder twice. It doesn't say felony murder, but there was a robbery involved. So he has 2 charges of straight up murder, and then there's a burglary charge. So I was wondering about that. Does that give you some bargaining room?
Well, that tells me that one is felony murder.
Okay. Are you allowed to try somebody for murder and felony murder for the same incident? Okay, so that's not double jeopardy.
No.
Okay.
Now, at sentencing, they may merge. Let's use an example. You walk into the convenience store and tell the cashier, give me all the money in the cash register. And he does. And we'll make this kind of fun. You have a co-defendant with you,
Oh, okay.
and you decide...
Might as well do it together, right?
You decide, well, I'm not going to leave a witness. And so after he hands you the money, you shoot him and kill him.
Horrible.
So you've now murder is knowingly or intentionally killing another human being. Felony murder is killing another human being while committing some specified felonies.
Which can be robbery,
Right.
arson,
Rape, major felonies.
kidnapping. Okay.
So on that one, you go to trial and you're found guilty of felony murder and murder. You wouldn't get 2 sentences for that. You wouldn't get, 60 on each one. They would combine, so you'd only get 1 sentence there. Now, your co-defendant standing next to you who didn't shoot can still be charged with felony murder.
Yeah.
He wouldn't be necessarily charged with murder because he didn't shoot,
Right.
but he would get felony murder.
Yeah, I do.
And there's also laws about if you get the conviction there for the robbery, you're not going to get, because if it's elevated robbery causing bodily injury, you would only get the minimum robbery charge as a separate count. And that's assuming you're not on the felony murder. So if you got convicted of all 3, you would get the murder, but then they'd have to reduce the robbery down to the lowest robbery count.
So I think with the co-defendant who didn't do the shooting, you'd have to see what his state of mind was. Whether he was going to be convicted of that felony murder, whether he actually knew that guy was going to draw the gun. Here in Indiana, you don't get much of leeway on that.
No, and you don't have to show that he was going to, you'd have to show that he knew he was going in to do the robbery.
Right. I mean, and I don't have any problem with the robbery part, but it is the felony murder. Sometimes I'm like,
I mean, several years ago, I had a case where the 2 guys were in a neighborhood and they passed a guy who was sitting on his front porch. Mm-hmm. And they came back around a second time, and one of the guys, or they both ended up going up on the porch, and they wanted to rob the guy who was sitting on the porch. Well, the guy sitting on the porch had a gun, and there was a tussle over the gun, and the lead guy got shot.
And killed?
And killed.
Oh.
And we did charge his friend with felony murder. Now, because he didn't have a weapon, he was a juvenile, I think we pled that to the robbery that he was aware of.
And so if it was...
So some of this can get very confusing. There's a lot of case law on sentencing and how these different things interact with each other. But the basics...
And it's up to the judges really to keep track of all that, because they ultimately do the sentencing.
Mm-hmm. And that's why you see sometimes a lot of charges. The other thing you'll do is if you have behavior that supports the other charges and you want to get that behavior in. So for example, in our robbery thing, let's say that the defendant had cocaine in his pocket.
Oh, no.
It's really not relevant to the murder case, but you may want to present that to the jury, so you charge him on the possession of cocaine as well.
That's besmirching his character.
Yes.
I mean, Lord knows there's a lot of cocaine in the United States.
But that's so that you can bring some of that in, because sometimes those behaviors are illegal. They're all part of the same incident, so it's okay to try them together. But you do have kind of a situation, it may or may not be real pertaining to what your lead charge is.
Well, he had something illegal in his pocket, so I guess you're allowed to bring it up.
But that's also kind of a discretionary thing as well. Sometimes we choose not to file stuff like that, particularly if it's marginal. We don't want to give the defense or the jury a reason to, well, gee, if that was questionable, what that was, then is the rest of this questionable? So you want to present a strong case that will withstand scrutiny. I mean, we're again relying on the jury to trust that we're doing the things fairly and accurately.
And every once in a while, a jury in Allen County can kind of surprise you. I
Yep.
mean, Tommy Gray was one of them, which was a couple of weeks ago. I did cover that, not gavel to gavel, but a lot of it. And I was telling Mike that he was charged with murder. We could get into murder, although I do want to do the sandwich thrower. And he was, what was I going to say now? He went to get his gun because he felt very threatened. And I was wondering if the prosecutors had chosen a different charge, like voluntary manslaughter, like involuntary manslaughter, if they would have been more likely to get the guilty charge. Because you have to show, it says in my research here that if you're going to do a murder charge, you have to show there was an intent to kill that person.
Mm-hmm.
And,
Knowingly or intentionally.
Right. And so, with the self-defense charge, it really looked more like he was going to defend himself. And he did shoot 3 times, so that's probably why you said, okay.
It's the 3 times that I would say that we would consider that showing his intent.
Right. So
A single shot is more likely to be kind of a, maybe that was intended to be a warning.
right.
Scared off and he missed. But yeah, when you have multiple shots fired, we usually will argue that that's evidence of their intent. And that's particularly tough in Indiana on attempted murder because case law says that we have to show that specific intent.
Right.
And so unless somebody says, I'm going to kill you, and then shoots, it's harder to get that conviction. And the appellate courts can be pretty tough on us on what evidence is used to show that specific intent and was it enough.
Right. It says here the difference, this is from the Indiana Code, the difference between attempted murder and aggravated battery hinges on the intent of the person committing the act. Aggravated battery involves intentionally or knowingly causing great bodily harm, permanent disability or disfigurement, or using a deadly weapon. But attempted murder requires a specific intent to kill.
Mm-hmm.
Right. So I just thought we would localize a national story here. And Mike said he's willing to go along with it. So on August 10th at 14th Street Northwest in the 2000 block, there was a 37-year-old Department of Justice trial lawyer who got fed up with seeing all the law enforcement in Washington, D.C., and walked over and started arguing, calling them names and things like that. And then he threw a Subway sandwich, was about a foot long, at a Border Patrol officer and hit him right in the chest. Now, this guy is interesting because from the research I've done of Sean Dunn, he is a D.C. native. He went to James Madison University. I figured that if he is a D.C. native, he probably went to some kind of a private school. I'm just going to project here that his parents, at least one of them, might have been a career government official. We don't know that yet. Bloomberg had something interesting on this guy. I'm just setting up so you know who the man was who did it. He was with the International Affairs, he's an International Affairs Specialist, no longer because he's been fired, with the Office of International Affairs within the department's criminal division, according to a Justice Department official. That office that he worked for handles international extraditions, prisoner swaps, and other overseas operations. And yet he lost it around 11 o'clock at night on August 10th. And through the sandwich, he was almost immediately, he was chased. They picked him up, took him down to the 5th District of Metropolitan Police Station. He is charged with felony assault. He was released on his own recognizance. And then on Wednesday, this is Sunday night, now this is the next Wednesday, there was a warrant for his arrest. His lawyer says that before he even knew it, there were 20 law enforcement officers coming to get him and take him back down to the station where he now faces a felony. So my question to Mike, I'm going to toss it to him in a minute, is that let's go back 5 years to the protests. And we've got somebody out there well-educated, from a privileged background, loses it, takes a Subway sandwich and chucks it at one of our SWAT team officers. What would the Allen County prosecutor likely charge that individual with?
Well, if you look back at the George Floyd protests, we did a lot of rioting, which wouldn't necessarily apply in this situation, but disorderly conduct, criminal mischief. Depending on the circumstances, we filed a couple of arson charges, but we also charged for broken windows.
Oh, those two guys, I remember them.
Under Indiana law, and I'm not that familiar with the federal statutes regarding this.
Well, he was charged, he's going in front of the metropolitan courts. He's not going into federal court on this, at least not yet.
Well, this is where all of D.C. is confusing because it's not a separate state. And everything is federal, but they have some limited home rule. I mean, that whole issue right now about the National Guard and federal officers helping to patrol D.C. streets is a little murky from a legal standpoint, a traditional one. But in our situation like that, if somebody threw what would be hard to just say is, I have heard the joke made, well, a sandwich is a deadly weapon is a bit of a stretch.
Oh, they're having a ball with this one. There are.
But they said, but it was a club. So
somebody pointed out a foot-long Subway sandwich does have some heft to it, right? Especially like you got the salami, the provolone, the onions, the tomatoes.
Our battery laws are structured. I mean, it is a B misdemeanor to touch somebody in a rude, insolent, or angry manner. That can go up to a level 5 if you use something as could be considered a deadly weapon. And that does get into the way in Indiana how you use it. So, a baseball bat is a baseball bat to hit a baseball with. But if you hit somebody over the head with it, that's a deadly weapon. It's a little harder to get a club sandwich in as a deadly weapon. I suppose you could strangle somebody by cutting off their airflow by shoving it down their throat.
This guy had a bulletproof vest on, so it probably bounced off of it.
So we would probably have, it would be some misdemeanor charges.
Well, I mean, that was most of the people who did get I don't know about rioting, but almost all the others, they were mostly misdemeanors.
Yeah, and that's how we're structured. If you don't injure somebody, and even some of the criminal mischief, depending on that, usually is dictated by the value of the damage that you do.
Right. That sort of leads to the next one anyway. This is actually was going to start out with. It says the idea of whether a charge or punishment, which we're leaving out the punishment part of it, fits the crime, also known as the principle of proportionality, is a fundamental concept in criminal justice systems worldwide. It is based here in the United States on the Eighth Amendment's prohibition against cruel and unusual punishments. Factors considered, judges and courts consider various factors when assessing proportionality. It's the severity of the crime. More serious offenses generally warrant harsher, we should say charges here, not punishments. Nature of the offense. This includes whether the crime was violent or non-violent. In this case, it was violent when he threw the sandwich. And
Just
whether,
an assault on a police officer.
right.
I mean, we take those very seriously.
And that's actually the charge, felony assault on, I have it here, and it does mention like officers. And whether it was a first time or repeat offense, to my knowledge, I have read nothing that Sean Don had any kind of record.
I would be kind of surprised if he had a record.
Oh, yeah, absolutely. I mean, I believe he comes from a privileged background. Individual circumstances, factors such as the defendant's intent, background, we just talked about that, any mitigating circumstances like duress or mental health issues are considered. But honestly, when somebody does commit a crime and the police bring you their who actually writes up the probable cause? Don't they sit there and they're...
Usually the police write it up because
Yeah.
they're signing it as they know what happened or what they saw.
Right. So how often do they say, well, this guy is really, schizophrenic, he's having a bipolar episode.
I think they utilize their discretion. It's like asking when do they give a speeding ticket and when do they give you a warning. It may depend on how you behave towards the officers. And on this, that's why we have, or Fort Wayne has the CIT team to deal with mental illness. Now, it's always tricky because when you're acting out due to mental illness or substance abuse and you commit a crime, it's a tough call for an officer to make. They don't necessarily know that you're having mental health issues. They have to respond to the behavior first. But clearly, if they have somebody who's obviously showing signs of mental distress and talking to themselves and doing other things, they take a lot of people for an evaluation at PBH or Park Center.
Right. I was just having somebody tell me this morning that, I think we need to get Judge Williams on this show because, the PBH evaluation is what, at the most 72 hours?
Well, the emergency detention, is 72, but
Yeah.
there's a 24 and sometimes it's much quicker than that. They go in and they're released rather.
Yeah.
So.
And much to the chagrin of the police officers, I have talked to them sometimes, and it's like they're still writing up the probable cause, and the guy walks out of there, because,
No, and they have the same criticism on some of the particularly misdemeanors that most of them are released on their own recognizance, and they may still be doing paperwork on an OWI, and the OWI, there's a time limit because their BAC has to come down, but
we could say that's the blood alcohol content there, yeah.
But for other types of crimes, there's always been a big controversy, like for shoplifting, that they're getting released before the ink is dry on their report.
Yeah, shoplifting is a huge problem. What do you think of this principle of proportionality?
I know the legislature tries to do that when they're creating laws. When they did the criminal code reform
In 2014? Okay.
They really took a big look at drug offenses. And at the time, they made them much more lenient. But other things, they left kind of the same. I mean, my pet one is after multiple offenses, habitual traffic violators can be of level 5. And it's hard to equate a level 5 because you're a bad driver, or you've got
a suspended license over and over again.
And that it's the same level as reckless homicide,
yes,
battery with a deadly weapon.
I think most people would agree with you on that one.
It runs into that where you want a sanction so people comply, but it's awfully hard to tell somebody that somebody drives a car recklessly and kills your loved one, that you can only get a maximum of 6 years out of that.
Yeah.
And you'd get the same for having a really bad driving record.
All right. Yeah. I mean, you just never got a license, driving while suspended. We did do a great podcast on that one. And, I think the habitual traffic offender needs to be investigated a little bit more, because it's like, I always wonder, what do other states do? What do other countries do? Mm-hmm. I didn't get a chance to look into that. I did go online to see, yeah, France has that. I can't remember whether England does or not, but they have the same problem, but they might have and it's tough to get a driver's license in France. It costs you money, just like it costs here. So it's something that we need to look into and see, how can we get these people on the right road? Because they might not even be bad drivers. They just don't have the license.
Well, sometimes the bureaucracy of the BMV combined with the fines and costs for poor people can make that prohibitive.
Yes.
And that's the one area that I think is very much attached to poverty. And I think I've used that example before, that middle-class folks tend to have their kids go through driver's ed, mm-hmm. so they get a discount on the insurance, but they're willing to pay that fee up front for that, whereas poor people are not going to pay for their kids. They don't have the money to go to driver's ed, and then they're frequently driving crappy cars. Mm-hmm. So they're just starting kind of in a hole at the beginning. And Indiana's tried to loosen up some of its driving restrictions. The courts are a little more friendly towards waiving some of those fees.
Oh, this one guy I know, that he was doing some work on my house as contracted with the contractor. He actually went to prison for being habitual traffic violator. He did never get, but his background was just exactly what you're talking about. There was absolutely no money. And it was Judge Avery who waived thousands of dollars of fines. God bless that man.
Well, in the legislature, I think it was around the time of the code reform, added the specialty driver's licenses that made it much easier to get a license, even with a big background of driving offenses. And so to be a habitual violator is really irresponsible on the driver's part. But it's really a crime of irresponsibility at this point, because unless you have refusals to take a chemical test as part of an OWI investigation, almost anything you can get the specialty driving privileges.
So, I mean, that's something else maybe I'll take to the activist element in Fort Wayne and say, why don't you look into this? Why don't you have, an event where people can come and sign up for these things and see how they can get some help, financial help too, so that they can get right with the law, shall we say?
Well, and I think there was, when they passed the expungement legislation, I think in 2011, 2012, there was a major public outreach at that point to try to get some of those things off of people's records, low-level misdemeanors and felonies.
If you get it off their records, but then if they still continue that same behavior.
Well, that is
I need to get to work, and so I'm going to get behind this car that I don't own, or whatever. I mean, there's all kinds of situations that where this happens, and the outreach could maybe. It's not up to the prosecutor to have it, but the outreach could be a little bit better. We might be able to keep some people not just out of jail, but out of prison, because prison is horrible. When he was at Westville, he told me all it was people fighting.
Well,
just one fight after the next, physically. It's like you're afraid to go to sleep at night.
There's some behaviors I don't understand. I mean, in the OWI area, certainly understand the addictive nature of some of that.
Right.
What I don't understand, though, is don't drive.
In this day and age,
No, but I'm talking
just
about
fall asleep in your car, and then when you wake up, you'll be sober enough to go home.
well, turn the car off first,
Yeah.
because that's still operating. But what I'm
They're just
saying
so drunk,
is,
they don't have any reason.
if you're that bad of an alcoholic, okay, and you haven't figured out a way to control it, stay home. Don't get behind the wheel.
Or, I mean, just make sure
You're not
that you
going to
have
get in
somebody
trouble.
that's going to pick you up. You know, but here we are. We're two people who can strategize and figure that out. Oh, maybe I shouldn't drive, you know? I've got somebody who can pick me up, and these people, they don't have the same kind of backing or something.
If you're going to prison because of OWIs, you're not thinking it through very well.
Yeah.
I mean, it shouldn't take, gee, if I stay at home and drink, does the policeman come in my house? Not unless I burn it down or do something stupid. But if I get behind that wheel and I'm out driving erratically, yeah, they're going to stop me.
Yeah.
And bad things happen once that happens.
I don't know. It's just like, it's impossible for me to reason that type of thing. So anyway, we have covered a lot today. Does the charge fit the crime, or what's in that probable cause? I don't know if you want to have the last word, Mike, before I sign off.
I think the other thing that people need to remember, though, about charging, that I don't think we've really mentioned, but we do try to take into account what the community standard is. And the importance of that is, ultimately, we have to present this through a fact finder, either to a judge or a jury. And if we're filing things that the jury doesn't believe should be a crime or are overcharged, they're going to give us a result we don't like. And now sometimes that's how you have to learn, and you kind of set your standard on that. But that's why I don't think in this particular day and age, as opposed to 30 or 40 years ago, if you file on low amounts of marijuana, our experiences, a lot of people, and the general surveys point that out as well, that a lot of people believe
70%.
that marijuana should be somehow legalized or decriminalized. Sadly, I mean, with that as an example, the research that's starting to come out now with the higher potency marijuana is that it can create a greater psychosis and brain damage. So right at the time that it's becoming popular and who cares is probably when it's the most dangerous.
Well, it is, and the stuff on the streets that comes from the illegal grows is really bad for you because it's sprayed with these banned pesticides. So
But
I can go either way on it because I feel like people are just going to smoke it anyway, and they're smoking this awful stuff that is doubly worse for them. It's not just the high potency, but it is the health factor of what they're putting into their lungs and their bodies, mind you.
But that is a factor that we look at, is what is that community standard? What is the public looking for? Does the public consider it a crime? One of the kind of other things we have, there's a couple of crimes that we do that, strangulation is one, that I think pre-George Floyd, not everyone understood there was really two ways to strangle somebody. You can cut off their air supply or their blood supply. So when we had those situations where somebody says, I can't breathe, and you're thinking, well, you're talking, so you must be breathing. Well, they were losing their blood supply to the brain and not the air supply. And that's what happened with when they were leaning on him on his chest, they were cutting off that blood supply. But to the general public, when we say strangulation, they're thinking that kind of thing. And we lose a lot of those counts because it doesn't fit what the public thinks the crime should be.
Well, Dr. Bill Smock will tell you that the effects of strangulation may not come about until 20 years later.
Yeah. So,
and you can stroke out.
So there's a kind of the medical definition, but there's then what people expect to see comes into play.
Yeah.
So there are things like that in the law that you have to be careful about as well.
Yeah, you have to bring in your experts when you do that. So next week, we're going to have a special guest. You could just wait to find out who he's going to be. If you have any idea that, or just want to let me know who you'd like to see. I mean, we had William Labredo on because actually somebody told me, hey, you should get the public defender on. And so we did, and it was a great show. And so now we're going to have another fantastic guest next week. As I said, I will let you figure out who it is when you tune in. But for now, we are The Probable Cause. You can find us on www.theprobablecause.com or our Facebook page, which has the same name. You can also listen to us on Apple and Spotify and hopefully learn an awful lot about the criminal justice system. So for now, goodbye. This episode is filmed and edited by Frosty Pictures. The Probable Cause is produced by Maumee Media.
Worried when I crossed the Michigan line, a cop from Steuben County waiting on I-69. A headlamp went out while he pulled me over. Charged me with possession after I rolled down the window.
Now that's skunk.
Indiana's a trip when it comes to weed. It's like who doesn't smoke or use gummies? Your grandpa, your brother, your rich friend from school? Hell, throw in the whole courthouse and my attorney too. It's time those assholes change these stupid laws. It ain't worth the paper for a probable cause. Sitting on a bar stool in my usual place, this guy next to me said he was looking for some cocaine. Hell, I just sold him an 8-ball with a little piece off for me. But my buyer was a cop? Should have known he was a creep. So I'm a dealer, right? You gotta be kidding. It's a rich man's drug. I just take it because I'm injured. 8 years in Westville with a monkey in my back. There's more drugs in here than you can shake a shank at. One dirty drug test, man, this system's flawed. Undercover screwed me in my probable cause. Street crimes never did me no favors. I'm hooked on Fetty. I'm a junkie, not a felon. Told that son of a bitch on the way to lockup. I can't seem to shake it. I need help, not mocking. What do you want from someone who's been through the system? Drugs all through the house before mom and dad went to prison. Throw me in jail and give me a fine? Someday I'll be dead and away from your kind. Now I'm at the courthouse in front of a judge. Can't say my public defender cares for me much. Crimes are committed on both sides of the law. God help me now with this probable cause. C-shift never gets old. Anything can happen when you're out on patrol. You think I'm just eating donuts, man? Give me a break. Nothing on this job is a piece of cake. Lights and sirens activated, this knucklehead wants to chase. Baby mama at the scene just spit in my face. Wife's worried that someday I won't be pulling up at all. You'll read about my killer in a probable cause. Man. She went through my phone and she seen my text. I told her forget it. It was just my ex. She took a swing and knocked me flat. Man, I went wild to get her back. Judge slapped me with a no contact order. Now she's got the kids and she's staying with her mother. So she started it all and I have to take the fall. You can read my whole story in the probable cause. When I was young, caught a case for dealing and did my time. Yeah, I got a record, but I was doing fine. Running my own business on the southeast side. Yeah, I got a gun. I kept it on hand. Told the cop my reason, thought he'd understand. In this neighborhood, you need some protection. Attorney thought I could get just community corrections, but the judge decided to send me to prison. Can't get ahead no matter how hard I try. Read the probable cause, it'll make you cry.
Whispers and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause.